So our panel for this afternoon is entitled Consent and Culture, Indigenous Lands and Traditional Knowledge. This is a panel where, and a discussion where some of our legal categories and rules are even more difficult to apply to some of the topics that we're talking about because we are so deeply grounded here in some of the most sensitive issues of religion and culture and ways of life. And so the panel that we've assembled today is bravely entering into this terrain that is admittedly difficult to talk about in a forum like this, but all of us in one way or another have devoted our professional careers to trying to figure out some of these issues and how we can use the law to work on issues of Indigenous culture. To introduce our panel, Preston Hardison is a watershed policy analyst for the Tulalip tribes and works on issues of traditional knowledge in treaty-reserved natural and cultural resource management, as well as climate change and biodiversity. He could really be on one of several panels, but we've asked him to be on this one. He's currently at work on negotiations at WIPO regarding Indigenous intellectual property rights, and in particular, traditional knowledge. Susan Anthony is an attorney at the United States Patent and Trademark Office, where she works on issues of global intellectual property, including review of Indigenous peoples' rights under the UN DRIP. She was recently named the USPTO's Tribal Consultation Official, and from what I understand, the Department of Commerce has a relatively new consultation policy that she is well-versed to talk about. Angela Riley is my very dear friend and co-author, as well as a professor at UCLA Law School and the director of the American Indian Studies Center at UCLA. She's the Chief Justice of the Citizen Potawatomi Nation Supreme Court, as well as the co-chair of the United Nations Indigenous Peoples Partnership Policy Board. I always have a hard time with that. I should just go with the acronym, which is UNIP. The way we're going to organize our panel is that Susan and Preston will speak first. Angela and I will both speak second. And just to signal things that are coming, the work of Susan and Preston more particularly talks about issues of intangible property. And Angela and I will focus somewhat on tangible property or real property. But I think one of the themes of this panel will be that some of those divisions are artificial. And for Indigenous peoples, land, knowledge, ways of life are very much intertwined. And it is exactly that struggle that we're trying to address through some of the legal advocacy moves, including FPIC today. So with that, I will turn it over to Susan.
I have been told that although I am from the federal government, I am welcome here today. I am very honored, deeply honored to be here. I also want to be quick to reassure all of you in response to Jennifer Weddle's challenge at lunch that the Department of Commerce is indeed one of those agencies that did hear President Obama's call. We worked very hard for a considerably long time on developing our tribal coordination and consultation policy. I know this because I was part of that group, and that ultimately became the policy that was released earlier this year. And then recently I was appointed as the tribal consultation official, an honor that I also take very seriously and hope to be a credit. What is our task for today? Kristen asked me and Preston to do the following: to share our perspectives based upon our work, and in particular my work with the U.S. Patent and Trademark Office, his work with the Tulalip tribes on the subject of traditional knowledge, substantive issues around protection, current domestic and international issues and struggles, especially concerned with the World Intellectual Property Office, World Intellectual Property Organization negotiations, and how we should think about FPIC in these contexts. And oh, by the way, please do it in 12 minutes. I'm always up to a challenge, so let me see if I can do this, and I'll watch the clock carefully. I think we need to start first with a definition of traditional knowledge, and so I am going to take the definition that appears in the WIPO IGC. There is no generally accepted definition of traditional knowledge, but the draft articles dated April 26, 2013, provided the following definition of traditional knowledge. Article 1.1. For the purposes of this instrument, traditional knowledge refers to, includes, means, know-how, skills, innovations, practices, teachings, and learnings of indigenous peoples and local communities or a state or states that are dynamic and evolving, and that are intergenerational, and that are passed on from generation to generation, and which may subsist in codified, oral, or other forms. Would anyone like to repeat that back to me? The United States government has generally been flexible on the definition of traditional knowledge. The government's view is that the term traditional knowledge means knowledge that has been held and shared between or among generations of a people. But the difficulty for the U.S. government is in the definition of protection. The example that we frequently give is that if protection means the right to exclude others from using this knowledge, then we do not believe that someone should be able to exclude others from using a steam room for healing purposes, the Native American sweat lodge, traditional knowledge that is shared by other peoples, such as the Finnish sauna or the Russian banya, or from tapping maple trees for making maple syrup, which again is traditional knowledge of Native Americans, widely used today in many of the states in New England as well as other states in the United States. Protected traditional knowledge, we take the position, means knowledge that is not widely known or used outside the community of the beneficiaries and is not in the public domain. Sounds not bad in the abstract, right? Well, let me step back to explain what the WIPO IGC is. 10 years ago, more or less, the World Intellectual Property Organization established an ad hoc group called the Intergovernmental Committee, or IGC, to discuss the protection of traditional knowledge, traditional cultural expressions, and genetic resources, or basically the relationship between genetic resources and intellectual property or patents. The IGC has a mandate to undertake text-based negotiations. We'll come back to that term in a moment. Text-based negotiations with an objective of reaching agreement on a text or texts of an international legal instrument or instruments which will ensure the effective protection of traditional knowledge, traditional cultural expressions, and genetic resources. These negotiations take place at the WIPO headquarters in Geneva, and as I said, they've been ongoing for about 10 years. Is there an end in sight? I'll get to that in a moment. Currently, there are 186 member states to the WIPO. At this time, there are 3 different texts, one for TCEs, one for TK, and one for GR. And we've been asked to focus in this particular session on the text for TK. But I do not think you can look at TK without also being intimately familiar with TCE. The texts for these areas are always heavily bracketed and heavily laden with options and alternatives. While it may be a little simplistic, just to give you a general orientation, I would say that the texts generally fall out between developed countries and developing countries. The draft articles for traditional knowledge begin with policy objectives, followed by general guiding negotiations. The U.S. government strongly supports the development of a common understanding of the objectives and principles of the member states' work. It's hard to know if you've gotten there when you don't know where you're going. I think that's a basic principle to which we all could agree. For example, peoples and communities have traditionally shared knowledge, and the U.S. government takes the position that knowledge should be shared, should continue to be a principle that supports the member states' work. In the latest session to address traditional knowledge earlier this year in April, Our viewpoint was that that text going into those negotiations was that the policy objectives do not describe what the U.S. views as a core objective of the work, which is to promote the sharing of ideas and knowledge. We compare the objective of forms of traditional Western intellectual property, or as we often refer to it as IP, and it's often very confusing to me because I'm involved in a number of projects at the office, including, for example, with the World Bank. And so when people write to me, we have a new person on IP, we have a person with a different view on IP, please orient me. Are we talking indigenous peoples or intellectual property? But at any rate, our objective is not to award exclusive rights, but to promote the dissemination of knowledge with the protection and enforcement of a new intellectual property right in traditional knowledge, which should be commensurate with the protection of traditional intellectual property, reflecting a balancing of interests and a balancing of rights and obligations. The objective of protected traditional knowledge should contribute toward the promotion of innovation and to the transfer and dissemination of knowledge, to the mutual advantage of holders and users of traditional knowledge, and in a manner conducive to social and economic welfare, and to a balance of rights and obligations. That may sound rather familiar to some of you, and you will recognize that language is coming from the trade-related aspects of intellectual property agreements, Article 7. The objective of protecting traditional knowledge is also to benefit mankind by encouraging the sharing of information. So again, you hear that theme in the U.S. government's position. That is to promote the public domain, yet also preserving to the holder of the traditional knowledge certain limited in scope and duration rights. Now, I have just shared with you what I think are key positions of the U.S. government. And Mr. Hardison will tell me, of course, if he disagrees with how I have captured them. But I thought rather than reciting to you chapter and verse what I know to be my team's or the U.S. delegation's position on the floor, I thought it might benefit you if I were to take a few minutes to share with you my own personal views. While I have been told that one working for the federal government or for working for any organization does not have personal views, I do have personal views. I don't know that my federal government would disagree with these personal views, but again, Mr. Hardison will be the judge. I believe that there are many problems with the draft articles, not only from the U.S. government's perspective, but from many stakeholders' perspective. A recurring thread for the U.S. government in these draft articles is the reference to traditional knowledge. The U.S. government says it should say protected traditional knowledge. It appears, at least to me, that we have the following principal issues for the U.S. government and, I believe, for the tribes and their representatives and other indigenous peoples who participate in the IGC. The first problem is public domain. While we can all agree in theory to a vibrant public domain, a robust public domain, it is far from clear what the limits of that public domain may be. Certainly, the area of exceptions and limitations is a hotly contested area in traditional knowledge. The draft articles contemplate that member states may adopt appropriate limitations or exceptions under national law under certain circumstances, and the draft articles strive to identify what those exceptions and limitations possibly could be. So, for example, one such exception and limitation could be the use of traditional knowledge in cultural institutions, in archives, libraries, and museums, and including for preservation, display, research, and presentation. Another example, also provided in the draft articles as an alternative formulation, could be the creation of an original work of authorship inspired by traditional knowledge. Inspired by. One man's inspiration is another man's misappropriation. A third area of contention continues to be the area of redress. What is the appropriate redress in the event of an unlawful taking or misappropriation? In fact, the parties at the table seem to have some difficulty in agreeing on what is an unlawful taking or misappropriation. And the fourth area, incredibly hot, the extent to which the new provisions would affect continuing acts of traditional knowledge retroactively. The U.S. government has made it clear that it cannot support retroactive provisions, what some may call repatriation or reclamation. As I have contemplated what the problems are in the IGC, and I have thought about the fact that I think, at least when it comes to the U.S. delegation, perhaps to the representatives of many delegations, and to Indigenous peoples, and certainly to the tribes within the United States, I think we're speaking two different languages. But I was trying to figure out how to possibly share that with you. What were the proper words? I do not have the expertise of so many of you in this audience as a skilled writer. So I happened to read very recently a law review article. Now I will tell you that over the years, law review articles have moved many of us to sleep. All of you, present company accepted. But this particular article moved me to tears. The downside was that I was on a plane in a middle seat and everybody on the plane was sleeping except for me. But I know that Rebecca Sosi will immediately recognize where this following statement came from. The problem associated with intellectual property protection within the historic framework of intellectual property law is that eventually this material will enter the public domain. Many Native American communities, however, do not want photographs and other archival material about Native American ancestral remains and cultural objects, particularly those that they have requested to be repatriated, to ever be in the public domain. Unlike traditional intellectual property law, which is geared to promote commercialization and industry, Indigenous intellectual property pertaining to repatriating human remains and cultural objects is not. This is a law review article that appeared in the Arizona State Law Journal in 2012, and it was written by a woman who is known to many of us as a leader in repatriation of human remains and cultural objects, Honor Keeler. Her article will really sober you up because you will realize what a huge and difficult issue the repatriation of human remains and cultural objects is, not only within this country but in the international stage. If the repatriation of tangible objects is that difficult, how much more difficult is it to get our hands around intangible intellectual property? So I really think that when we're looking at the IGC, we're looking at two different types of intellectual property. We are looking at traditional notions of Western IP, and we are looking at Indigenous intellectual property. So before I get the hook, I do want to share with you what I think are the domestic and international issues facing us in the IGC, since I was also asked to do this by Kristen. First of all, from a tribal perspective, understanding these issues is a huge and heavy lift. It requires not only a deep understanding of traditional notions of Western intellectual property, of patents, copyrights, trademarks, but it also requires a knowledge of traditional knowledge, traditional cultural expressions, genetic resources. A huge and heavy lift that is beyond sometimes even the most dedicated of government servants. Two, the tribes are very concerned that in the WIPO, they must sit as NGOs, non-governmental organizations. This is unfortunately a part of UN policy, but it has caused some tribes, I believe, to say, then fine, we won't go. Third, Geneva is viewed as anathema, very expensive. If you've been at it for 10 years, you're calling upon me to do 3 meetings a year for several more years. Another problem. Last, tribes have many other priorities that are probably more pressing than something as obscure as the IGC. Nonetheless, the water is rising, and I think that Kim Gottschalk made the case as good as anyone could possibly make the case at lunch when he said that if your voice is not there, then your voice will be overlooked, either intentionally or simply forgotten. Yet this is a text-based negotiation that is to a greater or lesser extent involving Indigenous peoples, depending upon your point of view, and it really needs an Indigenous people's voice. And in closing, I believe there is one other thing that is needed. Several people have already alluded to this morning. Does the U.S. government fully understand the intersection between Indian treaty law and these weighty issues at the IGC? I know I don't, but I'm committed to learning. Oops, wait, you asked me to talk about FPIC. That was the whole point of this remark. Well, I'll just limp out by saying that the U.S. IGC delegation has never had to enter into an in-depth discussion about FPIC at the IGC because the Canadian delegation already had bracketed the language. We've already heard recitations on what the declaration means as interpreted by the U.S. government, so I will not go there, but I will just say that, again, very thankful for the opportunity, but I hope you have not missed my call to arms.
Thank you. Before I start, I'd like to thank the Cheyenne Arapaho on whose lands I now speak. And I'd also like to acknowledge the presence of the ancestors who may have assembled here, drawn by the words, drawn by the prayers. And I ask them for their tolerance for my words, because I am on foreign lands and I mean no harm, and I always am ready to learn from them. I also want to start and say something to Kim, because I didn't have a chance to make my comment during his comments, but I think it's relevant to what I'm talking about. I just want people in this room to be aware of the next phase of removal. You've talked about physical removal of Indigenous peoples from their lands. One of the great removals I'm concerned about is what I call the great ecological removal. The first phase of Indigenous removal was to remove them onto their reservations and take them off of their lands. But understand what climate change is doing now, and global change, is it's removing the ecosystems out from under them. And we need to take that extremely seriously, because the rights that we talk about to resources and the knowledge associated with that cultural heritage and those resources is land-based, and the rights are defined by geography. Now understand, right now we're putting in corridors, we're putting in landscape features to help facilitate the movement of species out of their places. And the reasoning is we need to help biodiversity get to where it wants to go. But understand, when we start facilitating that movement, we're defaunating and depauperating the lands of Indigenous people. So again, I would tag that as a major legal issue for people in this room to address. And as we said, and I think we had a great setup here in the discussion, that these issues that we talk about on traditional knowledge are linked to the land, they're linked to the resources. And I will say that one of the great articles that's come out recently is on the necessity of property. And I want to praise that, because it brings up the issue of stewardship obligations that Indigenous peoples have to the land and to their knowledge. And so the problem with WIPO and the intellectual property system is it's extremely abstract. It treats knowledge as something that's divorced from anything else, and it says, here are the rules for the movement of knowledge. And then they say it's somebody else's problem to deal with the resources and deal with those other issues. That's not our That's not our bailiwick. And in doing that, that's one of the first places they do harm, because my understanding of the indigenous worldview is that in addition to stewardship over resources, there's also stewardship over knowledge. And so knowledge, you know, it has the same kinds of properties as a servitude or burden on the land. So you have servitudes and burdens on the knowledge that go with the wise use, the proper use, the appropriate time of use, the appropriate person or group who uses knowledge. All of those things are part of, that's a servitude or an obligation that goes with the knowledge. And so, as we've heard, one of the big parts of the intellectual property system is understand it was this grand bargain where there was to be a trade-off between protection for a limited point of time, a limited term, but then all of that would go into the public domain in order to enrich the world as a whole, or enrich innovation in society as a whole. And the idea was, if you grant permanent protection over things, then all innovation would stop. So that's how the systems worked. And again, as has been pointed out, it was focused on commercial use. So our issue here is to start addressing that. Now, I want to give you my conclusion right now so that I don't run out of time and we miss it, okay? This is what I call my clear and present danger, all hands on deck stump speech. WIPO has been going on 13 years. We now have a renewed mandate for 2 more years in these negotiations. Now understand, these are potential treaty negotiations. And so this would be, if it becomes a treaty, the first major comprehensive binding treaty that deals with genetic resources, traditional knowledge associated with genetic resources, traditional knowledge, and traditional cultural expressions such as music and dance and other kinds of physical, tangible forms as the Western world sees it. So after this amount of time, we're surprised and a little worried that we don't have engagement. And our problems are coming mostly from, right now, as Susan said, the developed world, and I will put the finger on the United States as being one of the major problems. Because, as she said, there are these principles that they're forwarding, principles of freedom of expression, principle of the public domain. They're proposing that there's a balancing test that indigenous peoples and local communities have an obligation to provide raw material for the West to innovate, that there should be a balance between society and their rights. Now, understand, this is not the language of sovereigns. This is not the language of comity between sovereigns. This is the language that sovereigns use when talking about balancing interest and rights among citizens. So if you look at the text, as Susan said, it's highly bracketed. And if your eyes roam through the text, you'll actually see one reading of the text is there's some potential here for a decent regime. But if the language goes through that says we have these exemptions, if you have traditional knowledge contained in a printed work in a library, that's off the table. Or in a museum, that's off the table, that gets an exemption. If you get something that's already in the public domain, and again, the US has introduced a particular phrase where they're claiming that any traditional knowledge that has been written down in tangible form, in fixed form, suddenly gets transformed into artistic and literary work. So you have a story that maybe you've gotten since time immemorial that comes from directly from your ancestors. And just because you've written it down, now it's transformed into something called an artistic and literary work. The significance of that is that once it becomes an artistic and literary work, the US will claim it is now bound by the Berne Convention, which governs artistic and literary works, which says that anything already in the public domain cannot be reprotected. So we have some movements here that are really threatening your rights and your sovereign jurisdiction over traditional knowledge. And so what I am proposing is we understand these negotiations start in February. Again, next round. After 1 year of a round, one on genetic resources, one on traditional knowledge, one on traditional cultural expressions, it will then go to a diplomatic conference. Now, a diplomatic conference is a higher level conference where you have people in the room who've never been involved in these negotiations, but have the authority to make decisions without having to go back to Capitol. So that could be good, or it could go very horribly wrong, because you suddenly have people who, I mean, the limited understanding in that room of the issues as it is, we're afraid that at diplomatic it may even go worse. Now, given that the main stumbling block right now, one of the big ones, is the United States, what we're proposing is that we have to, in the next 2 months, organize some effort to try to get to their positions and see if there's a way that we can get to their positions. We have a meeting coming up in 2 weeks. The Presidential Tribal Summit is one opportunity. But we have a lot of clever people here in the room that have a lot of connections, and what we need is we need to connect with tribal leaders who are willing to take the issue into the room at the Tribal Summit or to put it onto the table with the White House. And we need some other clever things, and we can discuss those with those who are interested. Okay, so very quickly, when we went into this, we thought we were going to get sui generis law, and sui generis means of its own kind. And of course, in our minds, we didn't mean sui generis of like new law, we meant customary law, anything but new or of its own kind, something very old. What we wanted was an accommodation and respect for customary law. And we thought we could do something interesting, which is expand the intellectual property system to do this. What we found is over the years that's narrowed and it's actually going backwards. And we're not getting that. So understand also the other reason why it's really important to pay attention is that the positions being taken by the USPTO are also the positions they hold domestically. So it's not just an international issue. And that's why they have to be dealt with right now. So understand that when you have a legal problem, it's kind of like it's in a gravityless space and it just keeps moving until some web catches it. In the United States and around the world, we do not have any robust intangible cultural heritage law. There's nothing really developed. You go to Cohen's law book, the most recent, and you get to the intellectual property chapter, it's just a regurgitation of Western IP law. So what catches that knowledge when it moves? It's the intellectual property system. Now, understand how difficult, because what I would argue is this is a master switch. How can we have any conversation over any issue with the American government if our knowledge is whatever we transfer, because we're going to have to put it into writing. And remember, our system works so that the minute we write it down, the intellectual property system steps in and says, hey, great. The minute we give it to the government, FOIA steps in and says, hey, great. There are all these laws that just automatically start going into play, whether we want them to or not. So if we want to have a conversation on adaptation, natural resource management, biodiversity conservation, it requires us to transfer knowledge or information. And if we start transferring that, then of course we have to deal with these intellectual property system problems. So again, I'm arguing we really need to start working on developing an intangible cultural heritage law here in the United States that fully respects indigenous sovereign rights. And so I'll give you one last thing that most people are not well aware of. About 2.5 years ago, Del Labrador, when there was a meeting many of you are aware of on UNDRIP, and there was a statement made by Del Labrador that nobody seems to have picked up on, but there is an actual policy on this by the United States, and we have it in a letter to the Tulalip tribes that I will share with some people. It says that the Department of Interior, their policy is, and they hold the policy stick, that the tribes have the tribal sovereign jurisdiction over cultural heritage and cultural identity, including both tangible and intangible aspects. That's the current policy. So we have something to work with, but apparently, USPTO hasn't gotten the message, hasn't gotten the memo on this. So Okay, last thing, FPIC, real quick. First of all, free is actually more important than just not coerced. I would say that free, think of it as in terms of an ecology of a situation. It's not just about being uncoerced, but it's about your role in being able to set the conditions for giving consent. So you know, there should be Indigenous participation in deciding what are the rules of the context in which I get consent. So that's free is a little more than uncoerced. It really, and it helps to take care of some of Tim's worries about this distinction between procedural and substantive justice, is that you have to set up those situations. Now, prior, you're going to have to think carefully, because prior in terms of land is really clear, but in terms of traditional knowledge, there's already a lot out there. So there's already knowledge that others have access to, so you'll have to decide whether it means prior to access or prior to use, to utilization. So there going to have to be some legal thinking on that. Informed, of course, is risk management, and just for Roger in the back of the room, I've written on this, and for example, people are coming to us to solve climate change problems, and we're saying, great, we want to solve those. We didn't cause the problems, but we'll help. But there's been some studies out on how this works, and none of them mention risk. They don't talk about the risks of knowledge sharing. So we have to really have some standards for what does it take to be fully informed. And again, think in terms of a life cycle. It's not about the benefits you get tomorrow out of climate change adaptation. It's about all the potential boomerang effects and long-term effects, because again, right now, if you release it and it goes in the public domain, that means what you've held and protected since time immemorial is gone, out of your control. And finally, consent, as we heard, it's really clear. It works for certain kinds of political, socio-political organization. We have real problems with pastoralists, the Waorani in Ecuador, the Yamana in Panama and Colombia. These are people who lived in widely dispersed situations that don't recognize hierarchical and representative authority. So how do you get consent there? Also, the issue that's been raised of consent between tribes. So WIPO tends to focus on the community and tries to localize it very narrowly, whereas in fact much knowledge is shared widely. So how do you deal with, say, knowledge of the Coast Salish? So let's, with that, I'll let you go, and maybe you can go off and do some of the targets that I set you to. But please contact us, and as Susan said, time is short, the water rises. If we're going to get movement on this, we have to do it pretty quickly, and we need tribal leaders, and we need people willing to work with us to start movement on the political end. Thank you.
Good afternoon, everyone. Take a little stretch here, and I really appreciate the comments of my co-panelists. Preston and I have had the opportunity to meet before and to work together before a little bit in Geneva, and it's really wonderful to be on the panel with him and to meet Susan, of course. I just want to start by thanking Dean Weiser of the law school for helping to sponsor and support this work, and to Kristen, of course, and Carla for putting it all together. I wanted to just also say I really appreciated the comments of Nicholas Kotz. I don't know if he's still here, the man from the mining company. But the one thing, I really appreciated his comments, but the one thing I really got out of it was that it's very, very costly to shut down a mine. So note to self, if there's something that we feel strongly about, if you don't know about the movement called Idle No More, go to Facebook and look it up. So I wanted to just start off by saying I had conversations prior to giving the presentation with various people who've spoken today, and kind of seeing a little bit of the tension is the wrong word, but sort of whether we're talking at an aspirational level or whether we're really in the weeds. And I think that this whole conference is meant to really kind of interject both of those viewpoints. Even though I am an academic, I like to think that I do try to stay somewhat pragmatic in my work. I really do work with Indigenous communities and I care about what happens on the ground. So I'm going to try to be both aspirational and pragmatic in this presentation, which I'm actually going to be tag teaming with Kristen at certain points in the presentation. So I just wanted to start by channeling Tim Coulter a little bit. I also felt like one of the things that needed to really be interrogated more in terms of having this conversation was just to really question the presumptions from the very beginning about consent, and about why that's even a key focal point. Because to me, it did seem like, and does seem like, I think as Tim suggested earlier, that in some ways that's a very kind of a utilitarian approach. It's sort of saying in the absence of real, true, complete rights over your lands, your territory, your self-determination, your sovereignty, your culture, in the absence of that and in the face of colonization, at a minimum, you should be told what's going to happen to you before it happens. Right? It seems like it already feels like a defeat. And I think he was expressing some of that early on. I don't want to put words in his mouth, but I had some of those same instincts. So I just wanted to throw out there facts that we all know and have already come out numerous times today. But we know that there's a worldwide drive for valuable and shrinking resources. This is happening in regards to mineral extraction, in regards to all kinds of fuel, in regards to water. It's happening everywhere for all kinds of resources. We also know from the presentations earlier in our own experience that many of these are on Indigenous lands. And I don't necessarily mean lands that are recognized as Indigenous lands, but on Indigenous lands. And then in addition to that, I think Indigenous peoples really maintain a cautious engagement with extractive industry if it is beneficial to them and it respects their rights. These are very minimal requirements. If you're a private property owner, think about what would be the minimum that you would require for someone to come in and do something on your property. It would have to be beneficial to you and they would have to respect your rights. It seems so basic, and yet, of course, we know in this context, it is really pushing the envelope to set this as a minimum baseline for understanding the engagement, especially of corporate interests with Indigenous lands. And then I have here, of course, just or not, because, of course, there are circumstances where either resource generation or exploitation or any kind of commercial industry might be completely incompatible with an Indigenous group's rights of self-determination and cultural existence. And that, of course, would be the ideal scenario where that group would be empowered to make that decision. So that's aspirational, right? We know that's not the case, and I'm going to talk about that in a little bit more detail in a second. So I wanted to just also kind of contrast. Part of the presentation today is to contrast a little bit about what I see happening in the United States and what I see happening internationally. A lot of the work that I've been doing in this area increasingly is international and engaging with people around the world who are facing these issues. And in many of the extreme cases, we're talking about situations where a group not only doesn't have free, prior, and informed consent, they have no recognized right to their lands whatsoever. And when those lands are taken and they are moved off, where do they go? They are living in countries where they face such extreme oppression and discrimination that they can't integrate and assimilate automatically into the dominant society. They are on the outside. They become a permanent, landless underclass, and it's happening all around the world. So I wanted to pick up a little bit on the points that were made by my co-panelists, which is to sort of think about, and they both have already, and Preston in particular have already talked about this, which is the connection between land and culture. So when we discussed kind of what this panel would be about, of course, we talked about that with Indigenous peoples in particular, you can't bifurcate the tangible and intangible aspects of life, nor can you bifurcate the aspects of material culture from intangible culture. Indigenous peoples' lives are connected through the land. It sounds essentialist, and I don't mean it to be, and I don't mean to say that every Indigenous person has that connection to the land, nor do I mean to say that someone who's not Indigenous can't have that connection to the land. But in my experience working with tribes both in the United States and indigenous peoples around the world, it is a common feature of indigeneity, common to almost every indigenous group that I've ever encountered, that there is a very closely tied symbiotic relationship with the land and with the place that they're from and from their traditional territory, and it's unique. And I haven't seen it in any other culture in the same way. So therefore, of course, if we really want to talk about the protection of indigenous culture, we have to start by talking about the protection of indigenous land and the protection of people to continue to be in one place together, which is, of course, where they exercise and live a vibrant culture, which is, of course, not a static thing. So just to give an example, and of course, many of these ruptures of colonization we've seen in the United States, and we're of course bearing the consequences of those. The loss of language, songs that relate to places, stories that are tied to specific places, creation stories, stories about where we come from, our ceremonies that have to be conducted only in certain places and can only be conducted in certain places. So if we don't have access to those places, those ceremonies cannot be conducted. Traditional medicines, traditional knowledge, hunting and gathering practices, etc. All of these, of course, show the symbiotic relationship between intangible property, things that we might consider to be covered under intellectual property law in the Western sense, but also sort of other property rights that are attached to place. So what I want to turn to now is what I call the property rights problem. And this really is, to me, and Kristen and I together have written several of those very long, very boring law review articles. And one of them is about this issue. And it actually is long and probably quite boring in certain places, but hopefully good in others. So this is what we call the property rights problem, right? Which is that if who you are as a people is attached to a land, and even to put in its most simplistic terms, if you need to be around other people who speak your language to speak your language, and those connectivities are ruptured through colonization and fragmentation of people, then the culture suffers. And you can't continue to have a living culture. It becomes very difficult to have a living culture. And of course, we see this with language and a million other examples. And so the pictures here, these are all examples of places that are sacred places to Native people in the United States that are outside, many of which, or most of which are outside of Native territory and are therefore threatened. So how does the property rights thing work? Well, in the United States, because of course we have tribal land and we have trust land, which is different from the way the situation presents itself in most of the world, though certainly not all of the world, here the issues tend to be when sacred places or the exercise of culture relies on continued access to and preservation of lands that are now outside of a tribal land base. Outside of the United States, the situation tends to be much more extreme, and that's some of the examples you've heard people talk about at lunch and at other places today, where people may have, an indigenous group may have actually have no recognized right to their land whatsoever, or they only have some kind of moderate right. There's obviously a huge range. The world is a big place, and different countries deal with the issues differently. The history of colonization in countries varies greatly, so the particular situation of any indigenous group is going to vary depending on their own history. But we do see examples all around the world where indigenous groups' rights are completely ignored to lands, or they're only consulted. FPIC, really the height of FPIC in certain situations is just to tell people what's going to happen to them before it happens, and then they're removed. So there was also a mention today at lunch of conservation, and I really appreciated the point, and I wanted to mention another example of that, in addition to conserving the land itself, examples that I've seen that in some sense can be fueled by the West, interestingly in ways that I think many people aren't aware, that there are places, especially with people I've worked with in Africa, where indigenous groups are driven off not just to conserve the land in some sort of kind of false state where no humans are in it, but to really either open it up to ecotourism for Westerners and also to open it up for big game hunting. So there are a lot of places where they want to get the indigenous people out so the big game can flourish, so Americans can go over and shoot tigers. And that is also seen as a major source of economic development in some parts of Africa. And the people, again, have no place to go. So I want to just pose two questions. The first is, what is the scope of FPIC obligations when the lands are outside the recognized territory of the indigenous group? The situation I've explained already. And then what are the limitations, if any, on the destruction of religious and cultural life of indigenous groups when cultural practices are tied to non-Indian lands? So to start us off with kind of the doctrine about what consultation requirements there are under US law, I'm going to turn it over to Kristen, and then I'll come back for some of the international stuff.
Thanks, Angela. And since I'm the timekeeper, I will try to keep myself on schedule. But I did want to talk a little bit about sacred sites law in the United States, because I think it is an area where we can see a lot of opportunity and some developing best practices with respect to a practical role for FPIC. So just briefly, when it comes to off-reservation lands, and of course on-reservation lands, for the most part, this is a gross overstatement, but tribes have the right to exclude, right? So they have the ability to make decisions about the treatment of their own lands, hopefully according to customary law. Off-reservation lands, there is a body of law in the United States that provides some procedural protections for what we call traditional cultural properties under the National Historic Preservation Act. So properties of religious and cultural significance are eligible for listing under the National Register of Historic Properties, and once they are eligible for listing, agencies that propose to undertake activities that may adversely affect those lands have an obligation to consider the impacts on tribal peoples in the United States, as well as to consult with affected tribes. And the standard under the NHPA is to make reasonable good faith efforts to consult with tribes. Now, as various folks have alluded to in the broader conversation about consultation, these rights of consultation are largely procedural, much like NEPA, as Jen was saying at lunch, but that doesn't mean they're not important. And of course, in my writing and some of those articles that Angela has talked about, we've been somewhat critical and somewhat constructive about the limits of consultation, of procedural rights. And I guess I'll say, on the one hand, making the right to consult just a procedural right allows agencies to go through a process of talking with tribes about the importance of their sacred site, the way it might be governed as a matter of customary law, and maybe to go through that process for months and years, and then to disregard everything they learned in the process and make a decision to permit some extractive or recreational activity anyway. There are some examples, however, where agencies have engaged in consultation and then used the information gleaned through consultation either to refashion the proposed use at a sacred site or maybe even to abandon it altogether. One of the cases I like a lot is the Wyoming sawmills case from the 10th Circuit, in which the Forest Service, the U.S. Forest Service, actually entered into a memorandum of agreement with some affected tribes with respect to the medicine wheel up in Wyoming that withdrew a certain area from eligibility for logging because it was considered to be a spiritual sacred place. I mentioned that example because that element of the memorandum of understanding is an example of consultation that works toward agreement, seeking agreement. And I think that is consultation that's a little bit more than lip service and moves us in the direction of something that looks more like consent. In fact, that concept of seeking agreement is exactly what NCAI called for when it reviewed the Forest Service's recent study on sacred sites policy around the country. And the Forest Service said, well, we're more actively trying to listen to tribes. And NCAI said, well, instead of just listening to them, why don't you take the consultation process and move that toward actual agreement? I think if we take this principle or norm or whatever we're going to call it, a free, prior, and informed consent, and start to use that as an aspiration in administrative law with respect to sacred sites and sacred lands off reservation, we could move in that direction. Another case that I'll just mention briefly, and I'm not sure if Walter Echohawk is here at the moment, but his book, which you'll have the opportunity to hear about and purchase later, mentions the Comanche Nation case, the Medicine Bluffs case from the Western District of Oklahoma. And in that case, and it's a rare win, and I think he calls it one of the 10 best cases in federal Indian law. The Western District Court there issued an injunction against an Army training site that was proposed to be built on sacred lands to the Comanche Nation, both because it failed NHPA and Religious Freedom Restoration Act standards. The NHPA claim was a failure to consult, and that, I think, more strongly than any other circuit, and certainly the Ninth Circuit has gone the other way, would suggest that perhaps there could be some teeth with respect to that duty to consult, and perhaps even to seek agreement under principles consistent with the UN DRIP. And just before I turn it over to Angela, and again, I'm looking for ways to bring this principle of FPIC from international law into effective domestic policy. I would just note that the very first U.S. agency to endorse the UN DRIP was the Advisory Council on Historic Preservation, which is one of the major agencies that has responsibility for sacred site consultation. And of course, the Forest Service and Park Service and others do too. So there too, I would encourage us all to take this principle and push it into best practices as much as we can, and with an understanding of some of the limitations that Angela and others have described. And I'll turn it back over to my partner here. How much time do I have? 2 minutes.
Oh, wow, okay. I have 2 minutes. All right, I'll be fast. I'm not going to talk about UNDRIP very much. There's been a lot discussed about it today, so I'm certainly not going to go through the articles. But we have talked in here, of course, about UNDRIP and ILO 169 as at least setting forth some of the parameters for consultation. I want to mention this because I've talked to people who are working in the field and they don't know what this is, and I feel like it's an appropriate moment to at least mention it. Out of the UN declaration, there were key people within certain UN agencies who wanted to collaborate across agencies to create what they called the United Nations Indigenous Peoples Partnership, which is a policy board that's supposed to have Indigenous experts on it and then representatives from key UN offices. You can see them here. I'm not going to bore you with discussing the structure. But the policy board was created, and I'm now co-chairing the policy board. And the idea is to actually raise funds, which we were able to raise at least an initial round of funds from certain countries, and to fund projects on the ground in Indigenous communities to try to actually implement the declaration, to sort of find a problem, find Indigenous groups on the ground that are working towards it, and help fund them towards that goal. So I want to mention it so that you'll be aware that it exists. And this is just an example. A picture was taken in Bolivia of one of the projects that we funded there around FPIC. So I'm wrapping up with this, and I just wanted to say there were a few things that I thought could be good ending points. So I wanted to start by saying, if we really wanted to think thoughtfully about consultation and we really wanted to take it seriously, what would it look like? The first thing is, again, channeling Tim Coulter, the necessary prerequisite is the rule of law, that you have to respect the rights to lands and natural and cultural resources of Indigenous groups. We know this isn't the reality in many places in the world, but that to me should always be the ultimate goal. We try to do everything we can to ensure that, because I believe that from that the other things come. If people are secure and safe and have self-determination within their own territory, then they are able to think about how to express and engage all the other rights that flow from that. But let me just hit a couple of highlights because I'm out of time. First of all, respecting tribal law and tribal culture. So a couple of people earlier today, including Calvin and Danica, both talked about really thinking about tribal law conceptions, and I think this is incredibly important. With a case I'm going to talk about for 5 seconds after this, I see a place where really having articulated tribal law on the importance of a sacred place could potentially be making a difference. So I think that for all these reasons I won't go through, I think it is really important to have articulated tribal law on the table in terms of lands and resources. Of course, this promotes rights of self-determination and tribal sovereignty in ways that we can all imagine. And the last one is sort of, I guess in some sense, appealing to the self-interest of the non-Indian person. And that is to say that what's in it for other people to preserve the lands and resources of Indigenous peoples? What do they get out of it? Because let's face it, I mean, people are asking themselves that, right? Like, what's in it for them? And I think one of the things, hopefully, and I'm sure this will come up in the climate change panel, is just to appreciate the value of Indigenous cultures, of biodiversity, of traditional knowledge, and of an ethic of stewardship over the earth. We all have to inhabit this planet together, and we're kind of screwing it up. So if we want to keep living on this earth and have any kind of respect for it and have our grandchildren have respect for it, then we've got to make some changes. And there's at least a model there of a way that people have coexisted with the earth since time immemorial that should be serving as something we could look to. And then finally, I just want to mention, this is a current sacred site issue going on in Oklahoma, so all the Oklahoma people out there, if you don't know about this one, this is about 10 miles from my family farm, and it's Longhorn Mountain. And in true Oklahoma tale fashion, I have family members on both sides of this fight. And as we talked about earlier today, understanding both law, understanding justice, both in terms of law and morality, I think situations like this really show just how complex that can be. When I hear people articulate on both sides of this fight moral claims of, on the one hand, freedom, liberty, property rights, individual rights, development, capitalism. And then I hear people on the other side articulate rights in terms of long-term spiritual connections, sustenance of culture, respect for ancestors, respect for the earth, and collective rights. And there are two worldviews. Trying to bridge those is very, very difficult, but hopefully that's part of the good work that we're trying to do. So thank you all for your attention.
So we have time for 5 minutes of questions, and then we will move on to our climate change panel. And Carla's got the mic, so we welcome any hands. Or we'll have to ask each other questions.
I have a question. So one of the things that we keep revisiting over and over and over again is this concept of tribal law and where it fits into this continuum. And something that I've been thinking about and wondering about in terms of FPIC implementation is there a way to sort of jurisdictionally wrestle this into the tribal courts so the tribes can develop their own law and start implementing FPIC on their own? Preston.
Yeah, I'll just say, understand what the Interior has said, is that if you want that jurisdiction, you have to assume it. It's the policy is now you have an open door policy, but to really make it happen, you have to assume it. Now we've talked about this. We don't know what the federal courts are going to do, but we do know when you have tribal law, has been suggested here, that they take it seriously, because if you go through process, internal tribal process to draft a code, they know then that this is the will of your people. That it's just not something that you're spouting off, that you actually have a process with procedural safeguards, with justice built in and all of that. And if you can provide that and then assert it, we think that's the way you build it from the grassroots up. You say, well, fine, you can, because of course extraterritoriality is going to be your big issue, and especially for traditional knowledge, is how far is your reach going to go. But we think the first step really is passing tribal code and passing tribal law. And then that provides the basis from which an outside court can look at your will and your sovereign will and intent.
Thank you, Carla, and that's such a great question. I guess I want to respond in 3 ways. First, Angela Riley has a wonderful article in the Washington Law Review that surveys tribal codes on cultural property protection. And it's a really wonderful empirical study of what's out there, as well as some of the challenges associated with taking customary law on sensitive topics and codifying it. I should probably let her describe it, but it's a really wonderful piece. I think you're right to point out the jurisdictional limits. A number of tribes that we've worked with have sought to, where possible and where desirable, codify their customary law, whether it's on subsistence, hunting and fishing, or sacred sites, et cetera, realizing that the reach might be only within their reservation. But as Preston alludes to, we've also seen, especially in the agency process, and I think this is where FPIC can be helpful, an agency, if it's taking the consultation process seriously, may well take tribal customary law on the appropriate treatment of a sacred site and put it into a management plan. Another case I like a lot is the Natural Arch and Bridge case, where Navajo customary law on the treatment of Rainbow Bridge actually made its way into the National Park Service's plan for management of that sacred site. And there is the trickling up of tribal customary law into federal policy on sacred sites, and that's one of those decisions that was upheld. So for lots of reasons, even though it's difficult and there may be good reasons not to put it into codified law, I think Preston and Angela are both right that there are a lot of good reasons to do it.
Thank you so much to all the panelists. That was just a wonderful, wonderful set of presentations. And so this question actually relates back to, I think, what Susan and Preston were talking about most directly, but I know that all of you have written and thought about this. So one of the things that I'm wondering if you can help me with, I mean, maybe others in the room, but I actually am not really clear on kind of the WIPO framework and structure and how it's intersecting now with the divisions of the UN, and Angela just talked about a new one that I didn't even know about, that actually are more devoted to looking at the issues that we're focused on today. And so just in a very simplistic way, I'm thinking to myself, wow, this is really weird, because we've been having a conversation domestically with the United States for so many years about intangible cultural heritage and all of the aspects that we're speaking about it, genetic resources and traditional knowledge. So we've been having this conversation, and I can't even think that we've distilled that into any coherent domestic policy. And now we're supposed to trust the United States to actually hammer out a treaty with other countries? I mean, so help me. I'm not kind of getting the building blocks.
I'll first speak to clarify that when I refer to the U.S. delegation, it is not comprised only of representatives from the U.S. Patent and Trademark Office, but in fact includes representatives from a number of agencies, including the Copyright Office, the American Folklife Center, which is part of the Library of Congress, the Office of the U.S. Trade Representative, the Department of State. Historically, we've certainly had representatives from the Bureau of Indian Affairs joining us, and some time back, Terry Williams, a member of the Tulalip Tribes of Washington, was part of that delegation. Since I haven't been at the table all of that time, obviously I cannot really tell you how and when things have changed for the better or worse. But I agree with you, Rebecca, that it is disconcerting where there have been spirited discussions and what we may have thought of as common understandings about these issues, that the delegation then may be espousing views that are not totally reflective of those discussions. That being said, from a federal government viewpoint, we're in a very difficult situation. It is not appropriate for us to represent the views of other nations. And there are 566 other nations, no two of which may agree, perhaps, on these issues. So there is that challenge for us. And even where the Bureau of Indian Affairs comes in, or other people with greater sensitivity to these issues come in, it is still not appropriate for us to say what should be the case. Nonetheless, we can't go in with a blind eye and a deaf ear. So I think we find ourselves in a very difficult situation.
Yeah, I think all of those hold. Again, we need tribal engagement, and without tribal engagement, we cannot move policy. And so, you know, Terry Williams and I have been participating for 13 years, and they're happy to have us there, and our voice is influential to some extent, but, you know, the U.S. is always coming back to us, where's our clients, so to speak. And there's also, so remember, State Department does not yet have their consultation policy in place. They're one of the agencies that hasn't had that happen. And that's what we need to push them on doing. They've not had these consultations. The BIA has not been represented since, I think, 2003 or 2004. So it's been a while. And we haven't, there's no, as far as I know, no even agency consultation when the U.S. bears for its positions on tribal agency, people with tribal skills. So that needs to change, but again, the time is so short. We're now in text phase, and if you know about UN processes, it means in text-based negotiations, you're no longer talking about issues so much. There's a lot less scope to putting new issues on the table, and what you're doing is going through and drafting legal text. And the process now has, there are 4 Indigenous peoples put into the Friends working group at any one time, only 2 of which can be on the mic. So a lot of the work is now being drafted in these subgroups. Now, of course, they come back to plenary, but that's where we're at. We're down to, there's 4 people that everything hinges upon. and that's the way it's probably going to be for the duration. So, you know, the way to, in my mind right now, is to move position before it gets there. But again, last thing, this raises some pretty deep constitutional issues. Of course, we know the Constitution says the tribes can't go and negotiate directly with, say, France. Okay, they don't have that direct negotiation, treaty negotiation right. But we think that's a far cry from saying that the U.S. can go and negotiate treaties on their behalf. And that's essentially what state has been doing forever. And we think in this new age of recognition of the sovereign rights, we need to get a compact with the Department of State that there be consultations domestically before they go and take positions overseas. Because as I said, if we codify some of these principles like that, again, once it's in the public domain, you don't have the right to FPIC. It's gone. So if they're going to codify language like that in international law, that's very threatening. So we need to make sure that there's some process to get input from the tribes.
We do have a ways to go, and this was something I should have made clear in my presentation, and I didn't. It isn't a foregone conclusion that the end result of these efforts will be a treaty.
That's right.
We're all over the board on whether it should be a treaty. It will be some sort of legal instrument, whether that means binding or non-binding, I cannot say. Obviously, in the many parties that are represented in the 186 member states, there are many who feel that a treaty is essential. But even if we were to have a treaty, then you still need to look to a particular country to accede to that treaty, and then determine whether its laws are in compliance with the treaty or need to be changed to come into compliance with the treaty. So there is much that can happen between here and there. But then the question becomes, should we just limp out and say, do no harm? Or do we have a meaningful opportunity to do something that is really a legacy for future generations?
So I want to thank all of the distinguished panelists for their incredible contributions. And before you thank them, just to adjust the schedule, I think we'll start the climate change panel at 4. And since we have one of our speakers unfortunately couldn't come, I think we can do 4 to 5, right?
Take 5 more minutes.
All right, so take 5-ish or 6 minutes, and then we'll come.
Come back at 4 after 5.
Okay.
5 after 4.
5 after 4. Brad Udall says, come back at 5 after 4. We'll do the climate change panel. Then we'll have our reception and Walter's talk. But with great thanks to the panelists. I appreciate it.